You've got to say, I'm a human being. God damn it. My life has value. I want you to get up right now and go to the window, open it, and stick your head out and yell, I'm as mad as hell, and I'm not going to take this anymore.
We're here at KingCast Mortgage Movies, and I'm quite certain that the defendants in my case are ecstatic. The judge, Robert B. Young, continues to claim that there is clearly no constitutional right for me to run video in public offices. Well, that notion is clearly belied by other judges, East Coast federal judges. So this is a public comment to Judge Young about what I've seen in his courtroom before and ongoing to this point. He expects certain things from me in his courtroom, and I expect certain things from him in his courtroom, okay? And what I expect from him is fair and impartial justice, and that has not been what was meted out to date. So then, Your Honor, we are in the midst of a simple case that involves a journalist's right to run B-roll video in a public building and to ask a few questions of senior public officials at such building whilst running a camera. The same rights that any citizen has using a pen and paper, unless you want to argue, Your Honor, that citizens don't even have those rights in Delaware. Now, you tell me what to do in your court, and you point out where I've erred, so I will take this opportunity to tell you the same thing. That's the beauty and value of the First Amendment, Your Honor, and I'll never let you or the defendants forget that. Now, when I walk into your court or Commissioner Freud's court, I will give you all the professional courtesy that any lawyer could muster, but I will not sit by idly when you, in return, give me less than that and cut me off in mid-sentence when I'm proving you wrong, as did Commissioner Freud regarding cameras in the court and instructive rule number 155. Now, your cultural hegemony is showing, Your Honor, in your decision, because your decision was not well-principled, as we shall see momentarily. But I want you to know that this commentary is not personal. You might be a great guy in private life. I don't know. I don't care. And you don't know, and you don't have to care about me either in my personal capacity. This is all about professionalism. So I can tell you right now that this is not a personal attack on you. It is a professional attack on your credibility in the courtroom. So then, what I expect from you as an impartial jurist is that you will not merely malign me with the pejorative guerrilla journalist label that you used toward me, but that you dug up somewhere. And I don't know where you dug that up, whilst ignoring the plain language of my complaint that referenced my experience as a daily and weekly newspaper writer and editor, Assistant Attorney General, First Amendment trial attorney, and experience as an escrow attorney. Okay?
Thank you, Your Honor. Yes, thank you, Mr. Speaker. Going to get my being done. What you did when you met the guy?
You didn't even mention the name of my website in your 29 June opinion. Another clear attempt to marginalize me. The name of the website is Mortgage Movies Journal. Now, I respectfully decline to participate in that sort of gamesmanship, Your Honor. Again, you claim to have decided this case on the pleadings, but I never call myself a guerrilla journalist, so that's your own unlawful bias manifest, creeping in like poison. Now, perhaps the most glaring thing that you and the defendants did in this case to date is of Pomykacz versus Village of West Wildwood, which I briefed and you all ignored. In that case, a citizen journalist was protected by the First Amendment in the New Jersey District Court after repeatedly shooting public officials at their office at all times of the day and night. You then lied about the holding in the Iacobucci case in Massachusetts to say that the First Amendment was not implicated when it clearly was implicated because he could not have been lawfully arrested in that case because of his First Amendment rights ab initio. Got me? And other jurists and lawyers have agreed on that. You have to have the First Amendment in place, to be protected against the Fourth Amendment violation. That's just the law. That's how it works. There's a predicate. Now, you've also ignored the Attorney General advisory opinion from 3 years ago that specifically warned public employees that banning cameras is highly risky because the law is evolving in a more permissive fashion. As a jurist, I shouldn't have to look that up for you. When I was an assistant attorney general, I know judges would go looking, in our files for those cases. Maybe you did look at it. Maybe you just thought I wouldn't catch it. I don't know. But whatever it is, it's on the table now. And I'm sure you may be scheming with the defendants in a way now to avoid addressing Tisdale versus Gravitt, in which the Georgia AG Olens and Tisdale's attorneys both sued the government when they shut her down for cameras at a public meeting. Now, the defendants in this case have argued all along that the older public meeting case of Whiteland Woods applies. Well, suffice it to say that the law is not as clear-cut on this issue as you attempted to portray it in your decision when you slammed me. So if you want to say that you choose not to follow those cases, then by all means do so, Your Honor. But don't you ever lie to me and expect me to take it sitting down. I wasn't raised to do that, Your Honor, and I won't do that ever for you or anybody else on the face of this earth. Now, in all of these cases, understanding the policy or policy in fact is the touchstone of analysis. Yet you and Commissioner Andrea Freud also refuse to allow me any discovery whatsoever as to what their policy is over at the Recorder of Deeds at Betty Lou McKenna, or what their authority was to deny me the right to run video on the day I arrived there. Meanwhile, Ms. Tisdale and her lawyer are running video of defendant Gravitt in the court case, in her case, putting it up on YouTube. It's right there.
Have you ever come across any action in Georgia or any other state where there was a claim for injury or damage related to an open sunshine or open meeting enforcement?
I'm not aware of one, although I can tell you one has been brought. The plaintiff in a Northern District of Georgia suit, Ms. Tisdale, the one who was there on the night in question, and the one upon who the Attorney General has brought this case, has sued the city of Cumming in federal court. We're in front of Judge Story right now, where she's claiming injury or damage. It's a 1983 action, but they've also included allegations that we violated the Open Meetings Act. But it's a 1983 action.
But if you want to keep Delaware squarely behind Georgia and squarely behind New Jersey and Massachusetts with respect to these free press rights, then you go right ahead and do so. But again, you don't lie to me or to the world public while you do it. And you don't ignore what are my clearly strongest cases, because I'll call you on it not only on appeal, but right here in the court of public opinion. Now, moving on from there. You failed to analyze this case on a summary judgment standard, even though there was crucial information in the court file that tends to show the defendants do not have a legal leg to stand on there. And most notably, their reference to my Free Press Kelly Ayotte lawsuit. But sir, that case occurred when she was not a public official, and the court ruled that the particular venue was private. You don't have that situation manifest here. And since that time, I put it into the record that I routinely shoot Senator Ayotte in public and at her office in the nation's capital and in New Hampshire at her office there. That's not because she likes me, Your Honor. It's because the First Amendment compels that she not arrest me or threaten to arrest me as the defendants did in this case. Now, you also failed to address the fact that Supreme Court Rule 155 clearly refers to cameras in trial courts, as I noted earlier, so I'll have to sue the Supreme Court in declaratory judgment later this year on that. Now, I've spoken, Your Honor, whether you like it or not. It's a free country, and I will bear no compunction to do it again as I deem appropriate. Now, I look forward to a more principled future in this case, devoid of the sort of tortured logic and intellectual disingenuity displayed thus far by you and by the defendants. And that is my record.
So